have a question about a revocable living trust. I've been looking at interest rates on savings accounts online, and the higher payers, ones I've checked out, won't let you open the account in the name of a trust. They say that you make the trust the beneficiary, which doesn't work because if you have so much money outside the trust, that automatically voids the trust, is my understanding. So it made me start to wonder, is there any reason that I could even keep a revocable living trust? When I established it, I thought I was going to be filthy rich because of a penny stock, but that was before Dan. So don't think that way anymore. And I'm just wondering if I should just dissolve the trust and be done with it. And if I did do that, do I have to have a lawyer do that, or can I do it?
Okay. So my disclaimer is I'm not an attorney, so I'm not trying to give legal advice. I would certainly have that reviewed with an estate attorney to see how that applies to all of your situation. But in general, the benefits of having a revocable living trust is that you don't have to go through the probate process. So if you have a will, or if you don't have a will and you don't have a trust, you don't have anything, let's just say, you have to go through the probate process so that your assets can be retitled and distributed to the rightful new owners. So a revocable living trust is kind of a perpetual entity, so it makes succession easy. So just like if you have an IRA, or even if you have a brokerage account that has a transfer on death or payable on death designation, those things kind of bypass the probate process. They're easy to transfer. So for example, if you have a TOD or an IRA and you go home to be with the Lord, well, your beneficiaries are going to contact the custodian. All the custodian's really going to need is their information to open a new account for them and proof of your death, so the death certificate, and they already have the legal designations on file. Those assets will transfer very easily. And that's the same thing that happens with a revocable living trust, is you appoint a successor trustee, and then, they kind of step in, and there's really no holdup. The probate process does cost, because you have court cost and you may have attorney cost and, some things like that. And there could be a delay in getting those assets transferred to the rightful heirs. For example, when COVID happened, a lot of the courts shut down or went to they were closed for a long time. They ended up with a backlog of cases, and that delayed a lot of estates from being settled in a timely manner. The other real advantage there is that the trust process, having a revocable living trust, keeps the heirs and the distribution of assets private, whereas when you probate a will, that becomes public record. So if those two things are important to you, then you may want to consider keeping and revising your revocable living trust. And I think there are a lot of situations where it can work just to name the trust as the beneficiary, but I don't know where you're looking to open the accounts, but I know, like on our platform, on a lot of other, discount brokerage platforms, that, we open accounts in the name of trust all the time. You just have to, have the proper documents. So maybe just keep looking if that's important to you. And if not, a lot of times people will spend a lot of money getting a trust created, but if they don't go through the steps in the process of retitling their assets, and or they don't have a good pour-over will provision in them, then they can just really kind of negate the whole plan that they just set up. So it's important to follow those instructions and make sure that you have things set up in the right way.